Yes, he's under oath, so you can receive, at this point, you can receive his testimony into the record.
Thank you. Is the audio okay? That's good. Great. First of all, I'd like to take this opportunity to thank all the members of the board for convening on what I understand is an accelerated time frame, and I'd also like to thank council who promptly arranged for a pre-hearing conference. I think it was just yesterday. I would start by saying that the Tiverton Town Charter is very, I guess you'd say, flexible and generous for petitioners in a recall. It is a very short, it's one paragraph, just a few sentences, and it sets really no limits on how long it can take a petitioner to gather signatures. It can take years perhaps. It sets no limits on how many signature gatherers can go out there and proceed to help gather those signatures. And it actually has really no limits on the justification, the reason. There has to be a reason, but it need not have any allegation of misconduct, and certainly doesn't even have to be true. But what the Tiverton Town Charter is very clear on, when it has chosen to be, is on deadlines. And one of those deadlines that is crystal clear is that within 7 days of receipt of the petition, two things have to happen. The local board of canvassers must, if it will certify, that is its deadline to do so. And secondly, the responding official must be notified by certified mail within 7 days. And that did not happen here. Now, we should remember that the Tiverton Town Charter is not a policy or an ordinance or sort of like a guideline. It is, of course, was voted on by the electors of Tiverton, and there have been a few amendment processes. I don't think that has ever been amended. But more than that, it has been ratified on many times by our General Assembly. So it doesn't just have the force and effect of law, it is the law, and it is essentially the equivalent of a statute. And so when a statute has a word like shall, it is not optional, it is not discretionary, it is not subject to some kind of administrative wiggle room. It is mandatory. And in this case, I don't think that there is any real debate here that the petition was received at the very, very latest on August 6th. I think that by the emails that you've seen, which I've stipulated to, there is some indication that the clerk or the petitioner stopped gathering signatures as early as August 5th. Of course, the signature started rolling into of course, the town clerk, as she stated, it also serves among many other things that she does well, is also the formal clerk of the Board of Canvassers. But we don't need to know exactly when we would say that she received those, but we know for sure that not only did the town clerk, but also the board itself receive them on Tuesday, August 6th. So that starts your 7-day clock for two things to happen.
May I stop you just for a moment, just so the record is clear? Do we have an understanding that the actual lists were certified on or about the 13th of August? Is there any dispute on that? Is there a factual dispute, Mr. Coulter, as to whether or not the signatures were finalized and certified on August 13th before the Board of Canvassers?
I'm willing to stipulate they were certified at the meeting of the 13th.
Okay, thank you.
And I know they're draft minutes, and I wasn't there, but I think the minutes from the August 6th meeting are pretty clear that the board itself, and certainly the clerk before the board was in receipt of those petitions. And the petitioner himself had stated that he had concluded with collecting signatures on August 5th. So for purposes here, I won't quibble and say that the board itself missed the deadline. I'll go ahead and concede that. So here we are, and the 7-day deadline has come and gone. And as far as I know, or I found out yesterday, and thank you for sharing those documents, Council, the letter that was dispatched to me on Friday, August 16th. And the Vice President, who was also a target of this action, I believe received his letter on the 19th. But in any event, whether it was received or not, and I think we should have a conversation about actual and constructive notice, is even if the letter had been signed and received, the local board still missed the 7-day deadline, because dispatching a letter on August 16th is more than 7 days after it received the petition.
And why do you say that the 7 days began to run at the time that the petition was received as opposed to when the signatures were certified?
Because that's the plain language of section 1209 of the.
Well, the language, and I'll cite it for the board and for you, and you can respond accordingly. And I'm quoting from the provision, Article 12, Section 1209 of the Town Charter. This is near the end of the provision. It says, within 7 days after receipt of the petition, the Board of Canvassers having certified the petition, the town clerk shall notify the officials involved by certified mail. So you can see, Mr. Coulter, that in addition to it saying within 7 days after receipt of the petition, that there is an additional clause that you haven't addressed, which is the board having certified the petition. That's the operative date, because if it was anything other than that, you'd be sending out a letter to the subject of it before he even knows whether or not the signatures will ever be certified. That could not be the purpose for giving him notice. Wouldn't you agree with that, Mr.
I
Coulter?
do agree, and I thought, I apologize if that wasn't clear. I think that language has two pieces to it. It requires the Board of Canvassers to act within 7 days if it chooses to make a certification, and then it requires, and then the letter has to be dispatched. And we know that that's actually possible, because if we started a 7-day clock on the 13th, and the letter was sent on the 16th, that wasn't difficult to do.
But they did. There's no question, you've already stipulated that the certified letter did go out, it's stamped for the 16th, is that right?
I'm stipulating that it went out on the 16th.
Correct.
I'm not saying that the responding official were notified as required by the charter.
The record also indicates that you did not, according to what I received from Ms. Mello, you had not received that certified letter.
I have not, and though I did receive the certified letter of the results of the meeting on the 6th, so for what it's worth, and that was helpful too, because they also sent it regular mail, which in this case they did not. I do want to respond as well, because section 1209 is so short. I do not believe that it's possible, you have to take the clause out. You can't read that sentence any other way than to say that the 7-day clock begins with receipt of the petition. But I'd also note that when you go further back into the relatively short section 1209, it talks about petition being filed with the town clerk. And so when you look at the language of the whole paragraph, then the petition is filed with the town clerk, and then when it's filed, it's received by the town clerk. There's no other way that receipt could mean any other thing.
So are you back to the original argument, which is that it was within 7 days of the petition being filed, or you concede under the language I just cited that it's 7 days from the date of the Board of Canvassers having certified the petition, as that sentence
No,
says?
I don't concede that. I read that language to say two things. It is a mandate on the Board of Canvassers to act within 7 days. And I think the reason why that is there is so that after a petitioner goes to the trouble, in this case, the petitioner, the recall effort had began as early as late December. So they've been working on this thing for 6-7 months, that the Board of Canvassers cannot sit on it, and that's the purpose of this being here. And that's also why you have the purpose of a relatively fast track, that the actual vote itself must be within 50 to 75 days. So I see the intent of this is quite clear, is that the government can't just sit on the petitioner's petition. They have 7 days to do what they have to do and notify the responding official. So I'm, for the sake of this argument, just saying that at the absolute latest, that the town clerk and the board for that matter would have been received the petition would have been August 6th. And of course, we could argue that it was earlier, but I don't think it's necessary to. I'd like to say too, and I mean, in the interest of time, I'm happy to stipulate that, of course, was aware that there was a recall effort underfoot, but I don't know that it's necessary to really go into all this context. I think the statute speaks for itself and it has to be followed in a mandatory way. But bear in mind the practical concept here is that, as I stated, this effort was afoot for many, many months, and it began, buzz began back in late December, barely a month after this council had been installed. And then it was in January, February, there was an inquiry made to Madam Clerk about potentially recalling all 7 of the seated counselors. Then it turned into 4. Then petitions were pulled on 3, and signatures began getting gathered, and I guess it came down to 2. It took the board, I think, as much as a month to process those. And it's just not, it's not the responsibility of the responding official to monitor and patrol every single aspect of a process that is going on for the better part of a year.
Would it be true, Ms. Coulter, that your argument is that the notice should have been sent 7 days from August 6th upon the receipt of the petition, rather than 7 days from the August 13th when they were certified? Is
That is
is that the essence of your
that's
argument?
the first part of the argument, and then of course the second part is that as we sit here today, I have never received by certified mail, and that is mandatory language in the charter. Shall be notified.
What is the purpose of the certified mail? What were you expecting to receive in the mail? What is your view of what is needed in that notice?
Well, it's certainly speculative, but in a more perfect world, I would have liked to have seen, more procedural guidelines, right? So, and I'm speaking from somebody that, we have an elected charter review commission in Tiverton, and that's one of the jobs I've had before, was to chair that commission, and we spent a lot of time actually, as coincident would have, looking at this. So, I would like to see procedural notes. Do you have an opportunity to be heard? Do you have an opportunity to have counsel? Do you have an opportunity, if you feel that any of the members have exhibited bias, how would you handle that? At the very least, and this is part of why I spoke a little about the context, as you have this process going on and on and on for months and months and months, the responding official should not have to be tracking every step of this. And, part of the idea here is to not let this distract from doing the job that you're elected to do. And so at some point you get a real, no kidding certified letter that says this is actually going to happen, instead of what you may read in the media or what you may hear, from people that follow social media. So I think that is.
But you heard it directly from the town. In fact, on August 6th, the date that you're saying is important, the town itself, through the town clerk, sitting here today, sent you an email that was sent out at 9:20 p.m. on the 6th to this effect. I need to let you know the BOC, Board of Canvassers, met this evening and certified signatures on your recall petitions. There were 605 for Justin and 546 for Rob. The meeting is continued to 6 p.m. on Tuesday, August 13 to complete the certification. The board has set 4 p.m. Friday, August 9th, as a deadline for objections or appeals, noted by Nancy L. Mello, Tiverton Town Clerk. That was received at that time, was it not?
I only stipulate to receiving the email that I responded to. I get a lot of emails, and a lot of these are sent to my official town account, which I very rarely check. So I'm not gonna dispute that they were sent, but I definitely don't keep up.
So what
with all
other
my
notice
emails.
would you get other than this in the certified letter? I mean, it's right here, you did receive it electronically on the date in question by the official of the town.
As I just stated, I did not stipulate receiving that email. There's one email that I replied to. I got a courtesy heads up that they crossed the threshold and they were thinking about it. And I wrote back to Nancy and Ms. Mello and I said, thanks for the heads up.
Mr. Coulter, is it your testimony before this board that you did not know that sufficient signatures have been gathered for your recall petition on or about August 6th?
I'm not sure of the date. I have an email from Ms. Mello stating that signatures have come in. I'm happy to stipulate whatever date.
That's the
was.
6th,
Is
sir.
that the one that I replied to?
There's no reply to this. There's a reply from Justin Katz that same evening. But my question is it your testimony before this board that you did not receive knowledge and notice from this town clerk that sufficient signatures have been gathered for your recall on or about August 6th?
I will stipulate that at least at some point before that date, I was aware that sufficient signatures had been gathered. I just can't, just can't stipulate the exact day.
So whatever purpose would be served by the certified letter, you actually had actual notice, or is that right?
Noticed that they had crossed, that, well, at the clerk's office, and their informal screen had crossed the threshold. And again, as I said, I'm happy to stipulate to actual notice on this.
Counsel, would it be fair to say that the first issue before us is determining the appropriate date for the notice as required by the charter, and whether the 7 days runs from August 6th or August 13th?
That is one of the questions. I don't think it's I think the initial question is whether or not the petitioner actually received notice of the requisite number of signatures for the recall. Once that's done, Mr. Chair, in my opinion, everything that was intended to be served by this charter provision was served by actual notice electronically. The argument presented by the petitioner, by the appellant, is that the mechanisms of a recall petition are stalled indefinitely until and unless a certified letter is not only sent out, which is what the charter says, but also received, acknowledged, and signed. That could result in absurd results where you could never recall someone so long as they can never receive that actual piece of mail. The critical issue, and the case law I think supports this, is whether or not the person has actual notice. So I think that's the first question, I think, Mr. Chair, is whether or not he had notice. That's now been established for the record.
And the next question is the appropriate time for the notice, is it not? Is that not?
It has to be timely, but obviously it can never be the 7 days of, the argument from the appellant is that it was required to be 7 days within a certain date. And he's saying that that 7 days is the 7 days must be the date that he received it by certified mail. Ideally, that would be something that you'd want to have accomplished by the charter. But the law, the case law, shows that when a person has actual notice, that can be considered as well by the trier of fact.
So then the issue before us really is whether or not the appellant here had appropriate notice.
Timely. That's correct.
Other questions from?
Any other questions, Mr. Coulter?
If I could just be heard at some point on the case law, thank you.
Mr. Coulter, I have a question. You indicated you have not received certified mail, certified notice. What is your position that because you didn't receive your certified notice, what is the status of the election?
Well, as I've indicated, I would be amenable without obviously waiving any rights if this were to go on appeal, but I think the practical sort of reasonable right thing to do, bearing in mind that of course the Board of Canvassers could potentially recertify and then dispatch, would be to follow that process. And simply, and if that just meant that this whole election is kicked back a month, so be it. But in that way, we've honored the charter, which I think is very clear law. We've avoided the decisions that have to be made here. So I'm not necessarily being so strict as to say that the entire thing can never happen, but I do think that we need to follow this 50 to 75 day clock. Did I answer your question?
Yeah, well, really, I was trying to get to the point. Were you looking for the notice to be given to you certified mail so that you would have sufficient time for campaign for the special election and recall?
Well, right. Again, I don't know that when you have such clear statutory language that the reasons or effect of that really matter, right? Because it is what it is. But to answer your question, my personal point of view is there's a lot of buzz about this. I'm not going to let it become a distraction. When I get the real no kidding notice that this is really going to happen, then I will begin to pay attention to it. And so that's my.
The point is you already have constructive notice right now. Okay. My point was that were you looking to receive the actual notice by certified mail so that you could campaign from that point on? Or you going to start campaigning now with respect to this recall election?
Right, well, my view is to give it not much mind until it was official. I also made the decision I wasn't gonna go in and try to challenge signatures and try to, go through all that, or try to challenge the fact that the allegations in the petition were patently false. let the process run. When I get the official notice, and I know when this thing's really gonna go. And obviously, I'm very familiar with the charter, having chaired the Charter Review Commission, which is itself an elected position. That's my personal view. Although I don't think my view is actually relevant to the clear statutory language.
If I may, Counsel, it seems to me there are two questions here. The timeliness, the correct time for the notice to go out, and two, the establishment of actual notice.
I think that's another way to phrase it, yes.
So I come back to the issue. It seems to me the first thing we need to determine is what is the date from which the notice should be, the 7-day notice should be sent? Is it the receipt of the petition or the certification that the petition is
Complete.
is complete and adequate?
Well, to that question, Mr. Chair, remember, I'm gonna read the whole sentence just so that you have it in mind. Within 7 days after receipt of the petition, the Board of Canvassers having certified the petition. This is all one sentence. The town clerk shall notify the officials involved by certified mail. Now, the appellant, in my view, his interpretation requires you to give no meaning to that middle clause. If that middle clause was absent, then I would agree with the appellant, which is that the 7 days begins to run upon receipt of the petition. But his interpretation nullifies the entire middle of that sentence, which says, the Board of Canvassers having certified the petition. Now, bear in mind, the appellant has now said to you that when he gets the quote, no kidding notice, that's when I will pay attention to it. Now, you're the trier of fact or reviewing this, but the email that Ms. Mello sent that I have summarized and actually read into the record and it's been stipulated to of August 6th, is that no kidding notice. It makes it very clear that there are sufficient signatures that have now been gathered. But he also was aware that they were going to reconvene on the 13th. So all of this was done in an open and notorious and proper way by the town. The fact is, clearly the fact is that the certified letter was sent out by Ms. Mello within 7 days from the certification, as I've just read, was required, but it wasn't received. Now, the last sentence says the following: the recall vote shall be taken no earlier than 50 days and not later than 75 days thereafter. It doesn't say thereafter the receipt of it. The only thing referenced is the date that it went out. So we're talking about technicalities in my view, but under even a technical view, as being presented by the appellant, the 50 to 75 days began to run after that certified letter was sent out. So everything so far has been complied with, and more importantly, fortunately, the petitioner, the appellant, has had full notice of every aspect of the process. Ms. Mello, that's not the only email. There are other emails going back to July where the town clerk or deputy town clerk kept Mr. Coulter in complete notice of all goings on of this petition.
It would seem to me that it would be helpful going forward if we were to make a determination as to whether the 7 days of notice comes from certification or receipt. And
That can be part of your decision.
And
yes.
it seems to me that that is issue number one before us. I don't know how other members of the board feel about this.
I'm trying to interpret this language.
And if I can be heard, I would respectfully disagree that, I keep hearing counsel say that I'm skipping over this clause. I'm not skipping it over at all. The way the clauses are arranged, the Board of Canvassers having certified the petition, that language is there to require the Board of Canvassers to do what it has to do within that window.
Mhm.
So I don't know if I'm not skipping it at all, and I think that has a real reason for that, because it forces the Board of Canvassers to do what it needs to do.
But it does say having certified. It doesn't say it doesn't use a future tense. It actually indicates in that clause that it has already occurred. You see that? Having certified the petition. That past tense makes clear that the action has already taken place, and then the last clause reads, the county clerk shall notify. There's a chronological order here, and I think you've skipped that middle fact that must occur.
Would it be helpful to settle that particular issue and then deal with the question of actual or notice or not?
I think they're both, yeah, I think they're both very important.
And that's just ultimately a question of legal interpretation.
Yeah.
That's what we're here for. Any comments from the board? On the issue of the meaning of the term in the charter as to when notice should be given, is it just receipt of the petition, or is it receipt and certification?
To me, after certification, once you certify it, otherwise you don't know whether these signatures meet the requirements of the charter or what. So if you don't have enough certified names on a petition, null and void anyway. So how can you send a notice to someone that there's gonna be a recall if you haven't made the determination that all the names on the petition are certified, you're registered voters in the town?
Any other comments?
I'd like to hear from the town solicitor.
Yes.
Yeah, I just wanted, before any decisions are made, I wanted to give the town's position if I could.
The Board of Canvassers or the towns? The Board of Canvassers?
Well, yes, for both. I mean, the Board of Canvassers, and is the town exhibited in this matter. So, you know, I think it is relevant to the question you're raising, Mr. Chair, so I wanted to interject before there's any decisions here. I'd like to ask the town clerk, if it's all right, you know, about the process and the timing, not to go over ground that's not necessary for this particular decision.
But pending before the board, according to the chair, is a legal question as to the interpretation.
Well, and I think it may be relevant.
The facts are relevant to the interpretation of this?
Well, I think it may be relevant, to hear from the clerk as to how she interpreted this clause.
That's entirely up to the board. I think that it's a legal question,
No, I think-
whether the clerk
can make that
interprets it
decision.
a certain way, that's.
Is there a motion with respect to this matter?
I find it the provision ambiguous. And I think Commissioner West has a proper position here, that it has to be certified after receipt. The notice goes when you get it certified.
Yeah. Is that your motion?
No second.
Okay.
Move the second. Discussion? Any questions? Any questions? All those in favor say aye.
Aye.
Any opposed? So ordered. It seems to me the next question is the question of adequacy of notice. Is that not correct, Counsel?
Yeah, there are two other aspects, which is adequacy of notice as well as timeliness of the appeal. But I think you can take them in that order, yes.
Mr. Counsel, can we just restate the motion that was just voted on for the record? I didn't understand the motion.
I hope that if the board did, that's all that counts, but if you want to read
I just want to be able to follow along.
I believe the motion was intended to mean that the 7-day notice period begins upon certification of the petition. Okay. Now, if we can talk now about adequacy of notice. Mr. Coulter, do you have something to say about that?
Well, I just wanted to, I don't have a lot more to add other than I do think we have a case on point, and this is not, we're not in the world of Open Meetings Act where you have to actually show a prejudice. What we are is in the world of filing a case, and it just is another one of these coincidences where we have recent guidance from our own Supreme Court, where the petitioner here, Mr. McLaughlin, was the appellant there. In the case of McLaughlin versus Tiverton, It's 186 Atlantic 3rd, 597, and Rhode Island Supreme Court case in 2018. And I'll just read a brief quote, which I think really sums this up, and it says, "Process is important, and even though McLaughlin received notice and an opportunity to be heard, the town's failure to comply with the process there is fatal." This is the Supreme Court speaking. And uphold that order would permit and not prevent manifest injustice. So
What
again,
process wasn't fair,
I
Mr.?
think-
What process?
Did they
was
fail
not
to
fair?
comply with?
It was a zoning case, so it was a question of whether in that case, the town brought a zoning enforcement action. They should have brought it in on its own right as rather attaching to an appeal of a variance.
How does that relate to this case? A question of notice.
It relates because you have our Supreme Court saying that actual notice is irrelevant. It's following the process that is important.
All right, so.
It actually says that for the town of Tiverton to have properly obtained an order requiring him to remove the garage, it should have filed a separate action in the Superior Court, not a motion for an order to comply filed by the zoning board in a zoning appeal. That's what Justice Flaherty says, the basis for reversing the decision, right?
No, I agree, that's the context of that.
The notice issue never came up. As far as Justice Flaherty, he didn't find any cause of notice, did he? It was that it was in, that there was a separate action required.
Even though McLaughlin received notice and an opportunity to be heard, the town's failure to comply with the statute was fatal. That's what it says. There's nothing else you can interpret it to say other than that. It's specific to the concept of notice. That's from our Supreme Court. So again, we have, and remember too, we're talking about the classic canons of statutory construction, right? So every word that is in the statute is presumed intended to have effect, and you have to interpret it to have, that it was intended to be there and to have effect. We can't just ignore that the statute says certified. You can't just say, well, it's an option, it's not an option.
If I
A
may-
question, if I may ask, Ms. Nana, how did you notify Mr. Coulter and Mr. Katz with respect to the pendency of this recall petition?
I sent certified mail as the charter required. In the packet that I sent to you, it has all the tracking of it. They attempted to deliver 3 times. They said they leave notice on it. It does not say I have to get a signature, even though in the complaint it mentions that a town official may have insisted upon signature. I contacted the post office twice after this. They told me both times that when you send certified letter, it requires they get a response on it. If you don't want a signature, you send it priority mail. And this clearly said to send it certified mail.
What address did you use?
I used 34 Lawton Avenue. I also asked the post office, is mail received at 34 Lawton Avenue?
And where did you get that address?
It is on his, that's the official address we have at the town for
For Mr.
Mr. Lawton, yes.
That's the right address.
It's on his nomination papers.
So you, in fact, did mail, within 7 days of the certification, certified mail to Mr. Coulter's address?
I did. And I tried to follow, and I believe I put the certified mail with the tracking number there.
May I, Mr. Chairman, can I just ask a procedural question here? It would appear to me that having approved the motion you just approved, the question of actual notice is no longer relevant. If the town has complied with the charter provision, and you found that they have, they mailed within 7 days of certification according to the vote you just held, then I don't believe there's any actual notice required. I believe
Well,
it's
actually,
status.
but the motion was, and I stand corrected by the board if I'm wrong, but the motion was, from what date does it run?
And I think we have stipulated evidence that.
We have that.
Yeah, so I'm not really sure what else is at issue, right? And honestly, I don't disagree with Mr. Coulter on the interpretation of McLaughlin. I believe that is a notice case, and I believe he's right about that. I just don't think it matters at this point. I think if the 7 days runs from certification, then your work here is done.
But.
Well, I think we need to determine the fact that notice was in fact sent.
Well, and I'm sorry,
That
but I.
is stipulated only from the exhibits.
Yeah, and we could, you know, very promptly, with a couple questions to the clerk, provide the certified notifications which we have here, and have her affirm that it was in fact sent out, as has been represented. But aside from that factual matter, I'm not really sure what's left to debate. I feel like we've run the course of this hearing.
I would respectfully suggest, I think we're glossing over the mere mailing of a letter is not notification. That's not the same thing, right? And Madam Clerk is correct, and my footnote was incorrect. When you send something certified, it does have to be signed for. That was my mistake, I apologize for that. Which actually helps make my case, even all the more so, that the charter, the voters of Tiverton and the General Assembly, for whatever word, wanted this word to mean something, and therefore they chose certified. And of course, it is part and parcel, as you just stated, you can't have certified mail without receipt, and that did not happen here. Whether that's good policy or bad policy is not our job to figure that out, just like any other kind of service or process.
Didn't you also reference an email?
Yes, and that's stipulated by Mr. Coulter. It's stipulated, as part of the record, and that is that the town did provide actual notice to the appellant on the 6th, indicating that the requisite number of signatures had been reached for his recall, yes. And it also, correct me if I'm wrong, but it also notified him of the next meeting of the Board of Canvassers on the 13th.
No, that was not my precise stipulation, because I don't believe I read that email. What I did stipulate is at least no later than then. There is some email in there which was sent to my Outlook account, which is the one that I read daily, that I responded to and said, thank you for the heads up. So I just want to be clear, this council is kind of overstating the stipulation here.
But
So-
actually, it's more than a stip. Mr. Coulter, you testified when I asked you, is it your testimony that you did not have notice? You said you did actually
I
have
said that
notice.
at least as late as August 6th, I was
Okay.
aware that the signature line had been crossed. I did not say that email was received.
Council, having determined the first issue that we've decided, what else is before us with respect to this matter?
Whether or not the appellant received actual notice, I think that's also part of the record, but Mr. Ciccione would like to make that clear on the record, and I suggest that we allow him to ask those questions.
I'd like to actually do two things, but I'll get that out of the way first, if I could. Ms. Mello, do you have in front of you a letter that you, from your letterhead, dated August 16th, 2019, I believe? There should be a copy of that in the package in front of the board as well.
Yes.
And can you tell me who it's addressed to?
It's addressed to Councilor Coulter
And what address?
at 34 Lawton Avenue, Tiverton, and it informs them that Board of Canvass has certified the recall petition, and the date for the special election will be on October 10th.
And can you just read the first line, not the whole sentence? just
Didn't
the
I already
first line?
stipulate that this was dispatched?
Yes.
I'm sorry, can you just read the first sentence of your line? I just want to be clear that.
Per Tiverton Home Rule Charter, Section 1209, I am required to notify you by certified mail.
Okay, and then you go on to describe the actions of the Board of Canvassers, is that correct?
Right.
And below on this, there's a tracking number of some sort. Do you know what that is?
Yes, that's the certified mail tracking number that we put on there from the town.
And you caused that to be mailed yourself or someone on your staff?
Someone actually took it to the post office and mailed it,
Okay.
and I followed up with tracking from them.
And so let me go to that. Attached, I believe, the fourth page after the fourth page behind the letter, there's something entitled USPS tracking and a tracking number. Can you tell me what that is, if you know?
That is, you go online, we do all our certified mail now online tracking, and there are several pages there with each attempt that they made to deliver, and the tracking, final tracking sheet. I backed it up by calling the post office. They said they had tried 3 attempts. They resent it out and still did not get signatures, so they returned it to me on, I don't know what day, but well after he did.
Are you familiar with
Can I
section?
ask this one? Can I? Usually when you send out a letter like that, and, the person's not there, the post office usually sends you a letter to tell you that you would have to pick it up, if I'm not mistaken. So I'm wondering, well, the reason why I say that is that, you know, if I didn't wanna receive the letter, I just said I didn't receive it, you know?
And if I may respond to that, Mr. Ramos, the comment that was made earlier about certified mail, I think needs to be addressed. It is not the responsibility of the town clerk or the board of canvassers to verify delivery. That is impossible. That is, you know, every bank trying to foreclose on a house would go out of business trying to, you know, chase people who didn't sign for their certified mail. This is not the purpose of certified mail. It is to simply provide proof that it was sent, that the notice was sent, and create some record for the town of Tiverton that they did in fact attempt to provide notice. I really feel strongly that we are off track in trying to determine whether there was actual notice. I don't believe the charter has any provision. I would ask the clerk if she is aware of any provision of regular mail or email or other communication. It's not. It simply says we have to send a certified letter, and as she just testified, she
But
did.
unfortunately, the local board, when I reviewed the proceedings, I can't tell what the local board did or did not do with respect to its decision. Now, this may end up going to the Supreme Court, and I want to make very sure that if it does, there is a full record on all of these issues, because that is his claim. I'm not saying that it has merit, I'm not saying it doesn't, but if we don't have a record showing whether or not he received notice, he's saying that's critical, I think, if this is reviewed by the Supreme Court, and that's the next step in the process. That's Mr. Coulter's right. If he does exercise that right, I want to make sure that body has everything it needs, so that's why I'm asking this question.
I understand. I just hate to assert relevance of an issue that I don't believe is relevant.
I
think we are digging a hole that we don't necessarily want to have to climb out
If
of.
I could briefly respond again, if the intent here was that the mere dispatch, if it was some kind of a mailbox rule, so to speak, in lawyer speak, then it wouldn't say notify, it would say mail, or send, or dispatch, or a whole bunch of words in the thesaurus, but it doesn't say that. It says that the official shall notify. The official, not mail something to the official's address of record. So I don't think this is, I think, maybe we can call it ambiguous, I don't know, but to me, it means what it says. And the very fact that the voters of Tiverton and the General Assembly chose the word certified, they must have intended it to mean that it was going to have a signature receipt. Otherwise, how else can you do that word meaning in effect?
Can I just, for the record, can I just ask Ms. Mello two more questions? To your purposes, Mr. Procaccio, a complete record, if that's what you're looking for, would require me to ask that, if it's okay with the chair. Ms. Mello, did you interpret section 1209 to require you to do anything other than mail a certified letter to Mr. Coulter in this circumstance? Were you required to email, or were you required to send regular mail?
No.
Okay. When you sent this letter, according to your timeline, which I understand is only for ID at this point, it's not admitted to evidence, but according to your timeline, you mailed, and as we just discussed, you mailed that letter on the 16th. Was it your understanding that on that date you were complying with the 7-day deadline in section 1209?
Yes.
Thank you.
You have a question?
Yeah, I just want to clarify one point here. So the only letter that you sent out was a certified mail letter, nothing else,
Well, no, I sent multiple emails.
other than emails, okay?
Other
I'm
than
talking about
emails,
using the US Postal Service.
I sent certified letter, yes.
Yeah, because the charter doesn't say send out notice by email.
No, that was actually a courtesy all the way through the process.
Right,
I
that's
just
a
sent an
courtesy,
email.
but we're talking about the due process of the system there. And apparently the respondent has raised a claim that he was not properly notified, therefore his due process was not protected. So the question here is, what notice, official notice, did you send to him?
I sent him certified mail as
So
the
he didn't
charter.
receive it, right?
Well, I mean, if you went away for a month and didn't receive it, I can't, that would mean we'd never have it.
Now, when did you get the letter back from the post office that it was not received?
I know I received it back, but I'm not sure, because it came in our, oh, I'm sorry, I received it back September sixth.
Yep. Okay, so on September sixth, what happened?
Nothing, by September sixth, it was complete.
Did you send them any notice, new notice or anything?
No,
Any other questions?
Yes, the post office held that letter for how long?
well, they didn't hold it, they again attempted to,
Okay.
the
Did they send notice to recipients that there is a certified letter for them?
what they had informed me is that they leave a card that he had, that there is certified mail to pick up.
Okay. And, but they will hold it at the post office for a certain number of days?
I have all the tracking sheets, that's the number of days they held it, and then they returned it to me. They made several attempts to deliver
Okay. All right, so
before returning it back.
they made the effort, but person was not at home, and they left notification that there was a certified letter to be delivered to that address.
Well, I can't speak for the post office, but they told me that's their process.
Right.
Mr. Rams?
One of the things that, I mean, I get a lot of certified mail, and, many times I'm not at home. There's always a notice from the mailman that you have, there's so long to pick up this letter, they have it on hold. So whether you're home or you just didn't see it, I think the onus is on me, who did not, whether I saw the mail, whether I saw the receipt, to go pick it up or not. I think the onus is on me to go pick it up. I don't think it's on you to go check around to see if the registered letters went to the individual's home, if he was home or not. I don't think that, me personally, I just think that that's between the individual and the postman at that time, not the board.
Counsel, would it be fair to say that the issue before us now is with respect to the, whether or not the notice given complied with the statute, the charter rather?
Well, the notice would not have, the notice would have satisfied the intent of the charter, but it could not.
Isn't that the issue?
Well, you mean the certified letter going out in and of itself satisfied the charter?
Yes.
The question is, assuming that there is a further appeal, because this is part of the challenge of the appellant, that is whether or not he was entitled to only that notice by certified mail and no other notice. That brings into question whether actual notice is legally sufficient. That's what I've been focusing on. There's case law that stands for the position that if a person is entitled to certain types of notice but doesn't receive it, but receives actual notice, and there's no substantial prejudice to the person, then that notice is deemed to be legally sufficient. Now here, there's no question from the oath, the testimony from the appellant, that no later than the 6th he knew the number of signatures had been reached. He was on notice that the ballot measure for his recall had been triggered by sufficient signatures and was allowed to show up at the next meeting if he thought otherwise.
So would it be,
Just to clarify that point, the communication, we don't wanna misrepresent what was communicated by the 6th, because we didn't know at that point how many of those signatures would be valid. So the notice was simply that there was more than.
we passed that.
I don't wanna misstate the town's position.
No, it did say that sufficient signatures had been reached.
Had been received by the town, but those had not yet been vetted through the clerk's office, so some of those were disallowed by the board of canvassers in those subsequent 2 meetings. So
We
I just wanted
passed
to
that
clarify that point.
The notice ran from the certification.
That's right, which was on the 13th.
So I think the issue before us is adequacy of notice, is there an opinion with respect to this board, with respect to the adequacy of
May I ask Mr. Craig a question?
Yes.
Okay, on this issue of notice, certified mail, did you receive any notice from the post office that a certified mail, a letter had been attempted to be served and come to the post office and pick it up?
Yeah, I think I had one notice. I was traveling quite a bit. I was in town, one day, and then I was, they come during the business day, so I was not in a position to go to the post office the next day. And I'd like to say
Yes,
too
sure, a
that-
couple things. Who else lives at 34 Lawton Avenue?
my family,
Okay, so there was somebody in the family who could have picked it up for you?
my wife works as well as I do.
Is there a
I
motion?
actually don't know, I'm not actually sure, I assume a family member can pick up a letter for you? I don't even know if that's, if it's gotta be a personal receipt, I don't think actually that would work.
Is there a motion with respect to this matter?
I'd like to just,
Let me see.
I mean,
Go ahead. No, I just have a question.
yes.
Mr. Coulter, you said you have an email that's specific to your role on the town council,
No,
but that you
yes.
don't check that
I
regularly.
just don't know,
How does that, so, can you say more about that?
Yeah, we have an email for convenience. All of my official town business with the clerk, when we get ready for meetings and whatnot, goes through my different email address. I do get email from constituents. A lot of media will write to me and ask questions and maybe community events, so I tend to check it about once a month. But I think even my colleagues here would stipulate that they know when they can reach me for town business, it's on my Outlook email. And in the emails that were stipulated, the one that you have is me replying to one and thanking Madam Clerk for the courtesy of the heads up that there were enough signatures at least to send it over to the Board of Canvassers. I think I responded maybe that day or the next day.
So, Mr. Coulter, it went to outlook.com.
The one I answered.
No, the one I've been spending this afternoon speaking of August 6th, that notified you of the requisite number, that went out to, without repeating it,
Right, okay.
it went out to outlook.com, the one that you check with regularity.
Yeah, well,
Yeah.
I get a lot of them, but
I guess
to answer your
the
question, I
point-
just,
yes.
I guess I'm embarrassed to say it, but I have like 8 email accounts and I can't keep up with them.
Right, the point I'm trying to make is, Ms. Mello, I know we're talking about the certified letter, so I'll be brief, but as a courtesy, reach out to you. I get a lot of emails. I think we can all attest to getting a lot of emails, but as an elected official, when business, I think it's important to read
Okay.
them all.
Anything else from the board?
Just a question, does the town council have a town email?
Each member of the town council has a tivitinri.gov. And, in correspondence with, Council Coulter, I often use the outlook.com, which I did that night.
Did you send any to the town?
Oh,
email?
there's
No.
numerous emails
Yeah,
here. Some,
I just asking a question, that's all.
some the Board of Canvass clerk that handles, the paperwork would have sent to, his town government, email. And others, if I sent it, more than likely, it's to either both that I send his agendas to, or I know he responds to me on Outlook, so I send it to Outlook usually.
Is there a motion?
Mr. Chair, I have a question of the clerk. Tell me, how would the town be prejudiced or disadvantaged if the election was postponed in order to give Mr. Coulter notice as he requests?
Well, we're in the midst of this election. We've had 60-some mail ballot applications already filled out. Tomorrow starts our emergency mail ballot system. This has been out there. I feel we followed the Board of Canvass, and I have followed what the charter said to follow. Beyond this, I don't know what more the Board of Canvass can do. We can't just say if you never signed for certified mail, that we're never gonna be able to hold an election. I have stayed as unbiased and kept this process going as best I can keep it going. There are numerous emails that are all just courtesy to say, we're at this number, we're at that number, every copy of the petition. And I'd just like to say, Mr. Coulter was the chair of the Charter Review Commission, and I know they did handle, some issue on that recall. But I, as one of the items sent before them, raised the issue on this, that the charter may be a little ambiguous on it, because there's no time frame on when we get all the signatures. But the Board of Canvas cannot certify until all the required signatures were there. And I will not send out notice without Board of Canvas certifying. I'm the clerk of it, I'm not the authority to do that, it has to be certified.
Right, thank you.
So I think the town would be prejudiced by this.
Dr. Ramos, do you have?
Yeah, I make a motion, notice that was sent out, I believe it complied with the charter, in regards to, the certified letter going to the individual.
So you're moving the notice.
Yes.
Is there a second to that motion?
Second.
Is that adequate, Council?
Just, since he, with respect to the board, I also think that if the board believes that he also received actual notice, it would be appropriate to make that clear in the event that there is an appeal to the Supreme Court.
Yes. So the motion is amended to reflect
Yeah.
that he actually did receive notice, and he received notice that complied with the charter and actual notice. Is that the motion?
That's the motion.
Is there a second?
Second.
Any discussion? All those in favor say aye.
Aye.
The motion passes. Is there anything else with respect to this matter?
I do not believe so, Mr. Chair, unless the appellant believes otherwise.
No, again, I'd just like to thank all of you again for hearing this on an expedited basis, and I appreciate all your time this afternoon on the working council, as well as my colleagues here.